Hello, beautiful humans. Good morning. This is the replay of the status conference hearing of Lori Vallow's status conference that happened this morning, Friday, January 10th in Arizona. And I know that Kresha with Difficult Research is covering this at the same time, so my apologies to Kresha. I, however, am remote, so I'm not able to stream the conference later, so because I am going on Mormon Stories later. So for those of you who are just here, just joining, this morning, Lori Vallow Daybell had a status conference in her Arizona conspiracy trial for the murder of her fourth husband, Charles Vallow. And I'm going to play the full conference here. It is only 15 minutes long, so I'm just going to go ahead and live stream it. And if I have time, I will comment afterwards. But if I do not have time, my commentary will have to happen later in the day. As again, I am going on Mormon Stories here in just a little bit to cover Sherry Frankie's new book, The House of My Mother. So I will now share the status conference hearing, and hopefully you will be able to hear it just fine as well. I'm going to mute myself while the status conference is on. And again, if I have time, I will comment afterwards. If I do not have time, I will have to do a commentary at a later time.
Hicks, whether or not it's appropriate to change the name or do a formerly known as on the case. Does the state have a position on that?
I think I'm okay with changing it as long as we still leave the A case. She was investigated, and obviously the first case, she was not
Right.
Daybell at that time.
All right, I'm going to order that the caption of the case would both cases be State of Arizona versus Lori Daybell, formerly known as Lori Vallow. There's a pending motion to produce. I'll ask the deputy county attorney. Your reply deadline, I think, would be due next Tuesday. You're going to be filing a response. I'm sorry.
I filed a response. If we're talking about I filed a motion for an extension. I actually filed that on Monday. I emailed it to your court.
You're right. I meant your reply will be due the 14th. Well, I might have to give you a little extra time because of the way inmate legal services works. Did you receive the state's response yet?
I did receive it yesterday, but
Okay.
I was hoping that I could put my response on the record today, my reply.
That's fine. Go ahead.
Ready?
Yeah.
Okay. Oh, let me get my glasses. Do you want me to stand, Your Honor, or can I just sit here?
You can sit there.
So the state has claimed in their response that these documents are not material in the case, and this defense is entitled to this specific evidence for the proposition that this evidence can be used to impeach the thoroughness and good faith of the police investigation and the intent of the prosecution. That's Kyles versus Whitley, 514 U.S. The acid test of this prosecution is not a matter of determining if the defendant is guilty of the crimes that the defendant is charged, but rather, was any crime even committed? And where is this evidence? This defense has yet to find any evidence of a conspiracy in the 100,939 pages that have been turned over by the state. The state does not get to say, like they did in their last motion to us, in their last answer, to say, oh, we gave you over 100,000 pages, so that ought to keep you busy. That's not how it works. These are serious charges, and these are serious consequences for these charges. In determining the actuality of a crime, the state is required to meet, in reality, not in theory, a standard of culpability that is defined by law as a crime. The state is required to meet the challenge of defense reasonably without bias, conflict, prejudice, or speculation. So the defense, we keep filing motions for discovery since we don't know if it's some kind of strategy of the state that they're holding back this actual evidence of conspiracy in hopes that the defendant won't have time to prepare a proper defense against the evidence that comes forward at the last minute. This court has denied every motion the defense has filed to acquire this evidence. The state has claimed in their response to the defense's motion that the defense's request is overbroad and wide sweeping. Is this the defense left to pinpoint where this evidence is and try to find it? No, that is not the law. The state is required by law to give the defense evidence of the crime they are being charged with. This is the purpose of the Brady Law and the right to due process. This is why in 2020, the United States enacted the Due Process Protection Act that provides defendants like me with greater protection, Brady versus Maryland. The state has continued to impede the defense from conducting a defense. This is a violation of the 14th Amendment of our great Constitution and the defense's due process rights. Today, the defense is requesting that this court do the following three things. One, order the state to turn over all evidence of a conspiracy since our trial begins in 76 days from today. I would also ask that they would pare down their witness list to these witnesses that will actually be testifying so the defense can conduct productive interviews. And then I would like for all motions and responses to be sent directly to the defendant in a timely manner. I'm having a really hard time getting this stuff. I don't get it from ILS to 7 days after things have been filed, after your orders have been rendered. I'm not getting these. This defense intends on starting trial on time without delay, and I request that also that this defense requests that the court grant the motion to order the state to produce all discovery of extradition at this time so that we can get started on getting prepared for trial.
What does anything in the extradition have to do with the underlying charges? Can you tell me that?
Yeah, it's to find out why all this started when I can't find any evidence that there is.
Have you
So
read the grand jury transcripts?
I have.
Okay, the grand jury transcripts summarize what the state's evidence they intend to produce at trial.
I understand that.
So when you say you can't find anything, that is the summary in the grand jury transcripts.
Correct.
Okay, so I guess I don't understand how an extradition a year or so after the fact, after the indictments, would have anything to do with the underlying charges. So can you articulate that for me?
I can, Your Honor. There's the detectives that are on these cases are all continuing to go back and forth with all of these different agencies. You have the FBI, you have all the different agencies that are working together. You have Rexburg, Fremont County, you have Chandler and Gilbert, you have all these people. Then I have them coming on, and they're going to be on the stand and they're going to be in trial and they're going to be saying what they reviewed. They've reviewed all these things. And there's communications between all of these agencies that I feel like that the defense is privy to. We should be able to have that and look at that and see where all this came from, where all this started, why they waited 2 years to make these charges. There's all these things, and why they decided to extradite when I saw someone sent me a news article 3 days before I got brought to Arizona that MCAO was putting out a release that they were not going to pick me up and they were not going to extradite me to Arizona until after my appeals were finished. So it's contradictory to that. I just don't know where it came from. And there's a lot of things that are mystery questions to the defense that we are entitled to according to the law.
All right, well, everything you've just told me, none of that would be relevant in the trial in the case in chief. Does the state intend on producing any iota of evidence or presenting any scintilla of evidence of anything that happened after the dates of crime that have been charged in the indictments?
The state, although there is information that occurred after that will relate to the conspiracy that has been disclosed to the defense, anything that occurred after the indictment, during the extradition process is completely irrelevant and will not be brought in during the trial.
I didn't mean the date of crime listed in the indictment. I meant the date of the indictment. So the state doesn't plan on presenting any evidence to a jury of anything after the indictment.
Correct.
So how would that, anything to do with the extradition, be relevant to your trial then?
I feel like it's relevant to the whole, Your Honor, in the sense that the police investigation and the intent of the prosecution, it doesn't make sense. I would like to be able to have that.
All right. Are you otherwise on track for your trial date?
Correct.
Are there interviews going on with your investigator or your advisory council team?
We're working on getting those set up right now.
Okay. Is there anything else we need to address today? This was sort of just a status conference to make sure things are on track.
I have 2 motions that I'd like to file with the court today.
All right. Do you have copies for the state?
I don't today. I thought you could make a copy.
Can we see them?
Sure.
I'll ask the deputy county attorney, from your perspective, anything we need to discuss here today? Yeah.
No, Your Honor.
How long, I'm assuming the 2021 case would be the case that the state intends to try first.
Correct.
How long would that case take for the state's portion to present?
Probably a couple weeks, Your Honor. I mean, and I say that obviously I'm unaware of how long defense will take for cross-examination. So I would probably ask to pre-screen the jury for significantly longer than that.
Meaning 3 weeks or 4 weeks?
Yes, Your Honor. I obviously, I do not know what Ms. Daybell is going to question any of the witnesses.
As we're looking toward that trial date, is advisory council willing to assist the defendant on the jury screening process if we do the electronic questionnaire?
Yeah, to the, yeah. to the
Okay.
extent that we-
All right, good.
I'm going outside of our scope, but yes.
Sure. I have received a motion for specific discovery from the defendant, well, 2 separate ones. Just going forward, can you title them maybe what specifically you're looking for? Because if you name all your motions the same thing, it gets a little difficult to keep track of them. But I have 2 separate motions for specific discovery.
Just like discovery.
For example, on this one, you could title it something like motion for discovery related to the Gilbert DR number or something like that, just to differentiate these. We'll make copies of these for the prosecutor and then we'll have those filed with the clerk today. One of your requests was to have the state send you directly any pleadings, which according to their mailing certificate at the back of the pleadings, they are mailing them to you. I can't do anything about how long the jail takes to process that. So I do recognize that there's probably some delays on that, so we won't hold you to the normal response reply times because of those delays that it takes getting through the jail administratively. All right.
In that case, Your Honor, could we have perhaps that go to my investigator, then I could maybe get those faster? Can he also be included on that?
Your Honor, I do email them to advisory council as well as in the court, so.
All right.
But there's not much else I can do.
Who's your investigator?
Jeff White.
And your advisory counselor in contact with him? Yeah,
They can be.
okay. So the record will reflect that the state's getting a copy of those 2 motions today, and then the state will respond accordingly. I'll just set a I'll have you reply within 10 days of the date of the filing of their response. All right. Depending on and then I'll rule on the motions as they come, or I'll set a hearing if need be. But at this time, I'm going to affirm the final trial management conference of March 18 at 8:30 a.m. in this division. Trial date's currently March 31. Again, the first case that would be heading to trial would be the 2021 case. Anything else for today?
Yes, will trial be staying before Your Honor? And if so, will we be staying in this courtroom?
I don't know yet. I'm going to confer with the associate presiding judge, and I suspect it will stay here and it will stay in this courtroom, although for jury selection, we may move to a bigger courtroom if we're doing in-person voir dire.
And Judge, I do know there will likely be the next of kin present. This courtroom obviously does not have a victim room or a witness room. With the media, that obviously makes it more difficult for the state to keep those individuals away from each other, from overhearing each other in this type of case. So obviously, we're happy to stay before this court, but would be requesting that this be reset or moved to the South Court Tower so we would have those accommodations.
I'll talk to the criminal presiding judge and the associate presiding judge regarding that. And it's just a matter of availability of bigger courtrooms. Anything else from the defendant?
I just was gonna ask, can we set both trial dates or how are we gonna do that?
You'll have two separate jury trials with two separate juries.
Correct.
So the first trial that will go will be on or around March 31st. We anticipate when that trial's done, we'll talk about how quickly we're going to do the second trial. Does that answer your question?
Somewhat, yes.
Okay. It's hard to set the second one without knowing how long the first one's going to take and then the readiness of everyone as far as the second one after the first one concludes. All right, we will be at recess on that matter. I'll take any motions under advisement.
And Doug.
Okay, sorry about that, you guys. I have multiple windows open, and so I missed that the commercial was coming on, so I apologize for that. Okay, I'm just going to do a little bit of brief commentary. I will have more thoughts on this later, but I need to get my head in a different space for my Mormon Stories episode. So I just want to say hello to everyone. Thank you for being here. If you're new to the channel, thank you for coming. Please subscribe. It's the best free way to support the channel. Please like the video. And I will be on again later today with my thoughts about this. Just briefly right now, I want to say how triggering it is to hear Lori's voice. I'm with all of you who feel that way. I did not watch the Sarah Boone trial, but this is my cousin that I grew up with. We were good friends when we were kids and teenagers and young adults even. We spent a lot of time together as young moms when Colby was little. My oldest daughter grew up being friends with Colby. And when the Coxes lived in San Antonio for 10 years, we were over at their house every day, or not every day, or every holiday, I should say, for lots of family gatherings. So I spent a lot of time with Lori, and it's really hard for me to hear her voice and hear her manner of speaking and all of that, knowing what she has done. I think I've talked before about how difficult it is to grieve a living family member. I've had to grieve the loss of the Lori that I knew because this monster is not the Lori that I knew. She has turned into something unrecognizable. The hard part is she still looks like Lori. She still sounds like Lori. And if she were talking about, you know, the fact that she liked one shampoo over another, she would still be using this tone of voice. She was always very insistent about, you know, her opinions. She was opinionated. She was, I'm going to speak about her in the past tense because the Lori that I knew, she was opinionated, and she was also, she also wanted everyone to agree with her. She wanted to get people to think the same as her, and she wanted people to see her in a certain way. She wanted to be seen as beautiful, intelligent, charming, and as, you know, really having it all together, being the best possible mom that there was. And of course, we know that she wasn't that on the inside. Her exterior veneer was very much all of those things. but obviously who she was on the inside was very different. As far as the legal of what she's doing now, she is obviously representing herself. She probably believes that she can do a much better job than her attorneys can because she is that egotistical. She's that narcissistic that she really believes she can do better than a trained attorney on this case. What she's trying to argue today in this motion is that they never should have extradited her to Arizona before her appeals were finished in Idaho. And there's really not a legal precedent or basis for that. And so that's why the judge did not, I don't think he granted her motion or allowed that, but she's looking for all of the discovery related to her extradition for that reason. I don't know if the judge granted her motion for that discovery. I didn't hear him make a ruling on it. So I don't know if he will just allow the state to file a response to that motion. That's probably what's going to happen. Again, as Justin Lum posts those motions on his Twitter feed or his X feed, I will show those and go over them with you as well. I do have a couple of friends who are attorneys who are helping me to figure out exactly what she's doing and the legal precedent as well. I also get lots of comments after the fact from attorneys, and I welcome those. I appreciate any help from attorneys because I'm not an attorney and neither is Lori. So I don't think she necessarily knows exactly what she's doing, although she has been appointed assistant counsel by the state, and she's also been appointed she's been appointed advisory counsel by the state. She's also been appointed a legal assistant who can help her to make appointments and file motions and things like that. So I will not have to testify. I don't have any material evidence in this case. The only thing that I have to talk about is her character. And when she was on trial in Idaho and the death penalty was still on the table, I was contacted by the mitigation specialist. The mitigation specialist's job is to find reasons why they shouldn't execute a prisoner or why they shouldn't be sentenced to death. If there's anything redeeming about the individual, or if there is any way in which they contribute positively to society in any way, the mitigation specialist wants to bring that out. And so she originally contacted my dad, and my dad asked me if I would like to speak with her. She told my dad she wanted to speak with any other relatives who wanted to. And so he asked me if I wanted to speak to the mitigation specialist, and I said that I would, but she probably wouldn't like what I had to say because at the time I was still very, very angry about everything that was going on. It's not that I've lost my anger, but I've processed it now. So it still does make me angry, but I'm not in the anger. So when I spoke to the mitigation specialist, I was still in the anger, but I was also very emotional about losing my cousin. I was also very emotional about sharing DNA with 2 serial killers. I was also very much on the fence about the death penalty. I thought, as a true believing Mormon, I believed that the death penalty was just and it was right. And I thought that's what I wanted. When it was taken off the table, I was upset. And then when Chad was convicted and sentenced to death, I really just felt hollow and empty, realizing that, you know, of course, killing him is not going to bring back the kids or Tammy or Charles. And it also is more costly for the state. It also subjects the family to more prolonged grieving because the appeals process is longer. And I have a lot of thoughts about the death penalty now that are very different than I did before. So anyway, I did speak to the mitigation specialist and told her about my mixed feelings. And, you know, there is a part of me that wants to believe that the real Lori is still in there somewhere and that's possible to get to her. However, all evidence to the contrary. She seems unremorseful. She seems unable to be introspective or self-reflective in any way. And so I really don't think that she's still in there. So no, I won't have to testify. I don't have anything material to present as far as the case is concerned. I wasn't connected with the family at the time of Charles's death. And so I'm grateful for that. But I will be at court as much as I can because I do want to see and hear all of the evidence and I will continue to report and comment on it. Between now and March 31st, I will be posting a lot of videos that have to do with the case and the family. I want to give a timeline. I want to explain to everybody, how all of the family fits together. And I also want to talk more about how I believe we got here. The manipulative behaviors that Lori developed in her young life, the fact that she was not held accountable, and all of the different contributing factors that made her who she is now and got her to where she is. So that's what's going to be happening on my channel between now and March 31st. And then I do plan to be at trial as much as I possibly can. So as far as what she was trying to do in court today, again, she's also she's asking to have her mental health records left out of the trial. And I'll just be interested to see which of those motions can go forward. Lori also filed a response to the state's response to her request for more discovery. She believes that the state is withholding information from the defense. And so she's asking for all the discovery to be produced. So that's basically what happened in court today. You heard the prosecution say that they're going to take about 2 weeks for their case to present their case. They also estimated that jury selection might take a couple of weeks. And also Lori and the defense basically said that they will be contributing to the electronic questionnaire for the jury panel to be polled so that they can sort of narrow it down to who they want to actually see in person and question in person. So Melody, I did do an episode about the death penalty and how I felt about it after Charles's case. I quickly made it private because it was pretty emotional, but it is on my channel. I think it's available to members only. But what I'm going to do between now and March is combine the 2 episodes that I did on that to give just a family member's perspective. And I will be posting that between now and then. So thank you so much for this trace on the case. I think we got to speak just a little bit. And I know you're a friend of Krusha as well, so I'm really glad to be seeing you. And I do have a perspective that nobody else has. I knew Lori as a younger person. We did spend a lot of time together. Even as adults, we were at family gatherings a lot, and I got to see sort of from the distance after she divorced Joe this sort of decline into strangeness. Excuse me. And even though I didn't speak with her directly, I did see all of Summer's social media posts about her and Janice's posts that she was going to the temple every single day. And although none of them were mentioning these strange conferences that she was going to or her relationship with Chad or anything that was happening with her marriage with Charles, I did get that information from time to time from other family members. And then once the case started happening, I was in close contact with other family members watching the case unfold in the media. And I'm the only person in our family who is out of the family system, really, except for, maybe one of my brothers, maybe both of my brothers. But I'm also the only one who's out of the church and speaking publicly about my feelings about the church, being critical of the church culture and the doctrine of the church that led to this. If you ask any mainstream Mormon, they will tell you the LDS church has nothing to do with these crimes. They will tell you Lori and Chad just took it off the deep end in a direction that nobody else would as far as the church is concerned. But the thing people forget sometimes is that these conferences that Lori and Chad were going to, where they were recruiting cult members, they were filled with mainstream LDS church members, filled with them. That's everybody who was at the conference center in Idaho when Julie Rowe filled the conference center talking about her crazy ideas. They were Mormon. They were mainstream Mormon. This case has everything to do with the LDS church. The leadership of the church won't comment on it because they don't want to be held accountable for talking about a public case. And also, other mainstream Mormons will dismiss it and say this has nothing to do with us because it is so difficult to dig into your own preconceived ideas, and it's so difficult to examine your own belief system with a critical lens and to say, hey, maybe there's something going on here that's not right. It's so much easier to double down on what you believe in and to dismiss things like this as sensational and strange and weird and nothing to do with us. So I think if you talk to any LDS person, they'll say that these are not mainstream beliefs and it has nothing to do with us. I don't think that's the case. I do think that Lori and Chad took things off the deep end for sure, but their theology is rooted in the mainstream LDS church. So I do talk a lot about that. I am critical of the church and its culture because I do believe that the LDS church does more harm than good. If you look at the people who are marginalized within the church, and if you look at the groups of people that they discriminate against, the LGBTQ community, I just did a video a couple of days ago, yesterday, Wednesday. I don't even know what day it is now. I think it's Friday. I just did a video on Friday about how the church has a sign on the outside that says visitors welcome, everyone's welcome. You'll hear individual church members, especially at the local level, say, we love the LGBTQ community. We welcome them in our chapels. We welcome them to be part of our community. But the actual dogma coming from Salt Lake City is, we don't want them in our chapels. We don't want them in our leadership. We don't welcome them. The policies that they just put out in August about transgender people others them, makes them seem like they are the criminals. So this church, the Church of Jesus Christ of Latter-day Saints, does not welcome marginalized groups. I was a second-class citizen in Mormonism because I wasn't married to someone in the temple. And then when I got divorced, I became a third-class citizen. And so it's so insidious to me that the church wants to say they had nothing to do with this. Oh, hi, Mormon Stories podcast. How are you? Probably checking up to see if I'm actually going to be showing up at the studio. So I do need to wrap this up, you guys. We're ready to do an awesome episode about Sherry Frankie's new book. So thank you for being here. Please subscribe to the channel. I'm going to be talking a lot more about Lori and Chad's involvement, the church's involvement, and laying out this case as we get ready for March 31st to come around. So thank you again for being here. Thank you for your support and your comments. And I can't wait to see you again on here, and go watch Mormon Stories later. Talk to you soon. Be well.